The court makes an amazing amount of decisions that ought to be made by the people. Antonin Scalia, Associate Justice of the Supreme Court of the United States. All right. Good morning. Welcome to another episode of the Liberty Dad podcast, a discussion on politics and culture. If you're tuning in live, I want to especially thank you for giving me your time so early. So a judge has banned or blocked, really, a ban on gender-affirming care. There was a ban on make sure I get this right. He blocked a ban on gender-affirming care here in Florida. Federal judge did. So this bill was passed in 2023 by the Florida state legislature, signed by the governor, and we are now blocked. So what we're going to do today is we're going to look at the bill because it turns out that I actually didn't review this bill last year. Sorry, happens, folks. But we're going to review it really quickly. Then we're going to take a look at the decision by the judge. Now we're going to kind of bounce around. We're just going to look and kind of get an overview of some of the reasons for the judge's decision. It is 105 pages, so I'm clearly not going to try and read it all to you because that would just I would lose every member of the audience. I'm pretty sure that I would only the diehards who are like, DL, I'm with you all the way, no matter what, which might be like one of you. So we're not going to do that. But we do want to get a sense of what's going on. So let me pull up this video. We're going to watch a news report, just kind of get an overview, bring ourselves into it, and then we're going to dive into the details. And let's see if I can if I can make it kind of interesting for 7 a.m. in the morning. So let's see. What do we get here?
I'm Forrest Saunders standing in Tallahassee. Major portions of that ban on gender transition therapies for minors now blocked. That's after a ruling from a federal judge just up the road here. But the governor's office says it's going to appeal.
Federal Judge Robert Hinkle delivered another blow to another controversial Florida law Tuesday. In his 105-page opinion, he found that SB 254, essentially banning gender transition care for minors and making it harder for adults, was unconstitutional, blocking the state and med boards from enforcement. Hinkle said in part gender identity is, quote, real, and that Florida cannot deny patients, quote, safe and effective medical treatment that has, quote, the state's full approval, so long as the purpose is not to support the patient's transgender identity.
Today, so many people are going to be able to resume receiving care from their trusted providers who had been displaced.
Attorneys for the plaintiffs said the ruling would help an estimated 100,000 plus transgender Floridians and that their legal team was already prepping for the state to appeal to the 11th Circuit.
You know, it's always hard to guess what any court of appeals is going to do. However, what I will say is this order is so comprehensive and thorough and robust and makes crystal clear that we proved our case under any standard of review.
Florida's GOP-controlled legislature and governor approved SB 254 last year.
We need to let our kids just be kids, and we have a very crazy age that we live in.
The argument from the get-go was that the treatments were harmful to children, lawmakers calling them experimental, despite backing from groups like the American Medical Association.
You're allowed to be stupid in this country. So there's no desire to stop this for adults. Children, it's a whole different story.
The governor's press team reaffirmed that position in a statement Tuesday and said an appeal indeed was coming. Quote, these procedures do permanent, life-altering damage to children, and history will look back on this fad in horror.
We're also going to be watching for whether or not state attorneys ask for a stay, basically putting Judge Hinkle's order on hold, allowing Florida to return to enforcing its law. We don't know if they will, but if they do, it's ultimately all up to the 11th Circuit. That's the latest out here at the state capitol. I'm Forrest Saunders reporting.
All right. So I also want to read from this article from the Florida Politics. And I think you'll find this helps lead into what we're going to read here. So let me zoom in a little bit, make it a bit bigger. Federal judge tosses Florida's ban on gender-affirming care for adults and minors. The legal ruling is a substantial setback to both the DeSantis administration and the legislators who sought to ban certain types of care, including those available to minors. A judge is completely blocking Florida laws dealing with gender-affirming care touted by Governor Ron DeSantis and GOP legislators. It's actually not accurate. We'll see why in just a moment. U.S. District Judge Robert Hinkle, who had previously blocked Florida's ban on Medicaid treatments for gender dysphoria, declared unconstitutional state laws and rules that prevent minors from accessing puberty blockers and hormones. Transgender opponents are, of course, free to hold their beliefs, Hinkle wrote, but they are not free to discriminate against transgender individuals just for being transgender. In time, discrimination against transgender individuals will diminish just as racism and misogyny have diminished. To paraphrase a civil rights advocate from an earlier time, the arc of the moral universe is long, but it bends toward justice. That's going to be very important when we look and see what was the rationale behind blocking this from Judge Hinkle when we look at his decision. Hinkle's ruling applies to both adults and minors seeking treatment. Brian Griffin, a spokesman for DeSantis, said the state would appeal Hinkle's decision. As we've seen here in Florida, the United Kingdom, and across Europe, there is no quality evidence to support the chemical and physical mutilation of children, Griffin said. These procedures do permanent, life-altering damage to children, and history will look back on this fad in horror. Hinkle's ruling does not apply to any type of gender-affirming surgery. This is what I meant when I said earlier that it wasn't a complete ban, but to bans on the other types of treatment that had been in place. The judge also cited testimony from physicians and surgeons who had achieved results with treatments such as puberty blockers. The legal ruling is a substantial setback to both the DeSantis administration and the legislators who sought to ban certain types of care, including those available to minors. In his decision, Hinkle concluded that some lawmakers backing the legislation acted with, quote, discriminatory animus, noting, for example, Representative Webster Barnaby's public tirade, what he called opponents of the bill mutants and demons. That's going to be important as well. The initial lawsuit was brought on behalf of transgender children and parents. The litigation was filed against top health officials in the DeSantis administration and the boards that regulate doctors. So this article is a nice little lead in understanding exactly what is going on with this decision. Now, I want to say from the outset, I have said this before. I oppose puberty blockers for minors for the treatment of gender dysphoria. Okay, so I'm opposed to it. I'm absolutely opposed for surgery for gender dysphoria for minors. And when I say puberty blockers, just think of it also as hormones. I know they're not the same thing, but sometimes I forget to mention both of them. So I personally oppose these. Now, I really oppose any legislation at the federal level, and I will always reject any legislation because I think that is a bad place for this kind of legislation. The state, a lot of it depends on how was the legislation written, and then when I read it, now mind you, I'm not a lawyer, so what I do is I try to read a piece of legislation and I try to think in my mind like how could this be used in ways that I wouldn't approve of. I want to make sure. You might think of it as a very strict test, and there's some legal terms that you can use in determining whether something is constitutional or not. I tend to look at it very strictly. I'm not really thinking of it, and I don't really take a legal approach per se. But if there was a Venn diagram of how I look at bills and some ways that judges will some methodology that judges use to determine constitutionality, I would overlap with their strictest in some ways. Because for me, I generally oppose bills, like most bills I actually oppose for one reason or another. Sometimes I just think they're bad bills altogether. Sometimes I think that they're very poorly written. Sometimes I think that the idea is good and that it's written too vague, and that vagueness means something scary, like what happens if my opponents have this bill in their hands. So there's a number of reasons why I would oppose a bill, and in many cases I just simply oppose it because I say this is something that we can deal with without legislation. If we withdraw all the power plays, then what we can have is we can have a conversation in the community. And I think that things like stigma and other non-legal routes would resolve our problems without legal without legal without the legal route and without endangering us from abuses of that same law, because we've seen that, like, it's the running joke, whatever the title of a bill is, that's what it doesn't do. Well, it's kind of similar. I look at it and I say, you know it doesn't do that, which means it does something else. And if a bill was meant to like help me, like let's say it's a bill for short people, then I would say, well, it's like this is a bill entitled, maybe titled the Assistance for Short People bill, something like that, right? I'm just making it up off the top of my head. Then I would say, number one, it's going to do the opposite. But then number two, as a short person, I can probably expect that the bill would actually harm me rather than help me. So not only does it do the opposite of whatever it says it's going to do, but it actually may do harm in the process to the people that it's claiming to help. So this is the reason why I generally oppose bills in the first place. So let's take a look at this bill, and let's just see. Maybe there's some good that we can get out of it. So let's see. Maybe make sure that I've got the. Let's see. Nope, that's the okay. Perfect. So let's go over here. Get myself. All right, perfect. So this is Senate Bill 254, which was passed last year. So we're going to look through this really quickly here, and we're just going to determine whether or not I would have supported the bill as of last year. Like if I had done this bill review last year, would I have supported it? So the very beginning, it's just kind of like this big summary of what the bill does. So we can skip on past that. And it's only 10 pages. Okay. Which isn't terrible. The first thing I look at is, when I look at a bill, how long is it? If it's 1,000 pages, then I'm really, really skeptical whether or not I'm even going to support the bill from the outset. So we get down here, and just as a reminder, what tends to happen is these bills, they, like 10 pages doesn't mean 10 pages of new stuff. It means 10 pages where they've taken existing statute, put it in there, and then where they're going to add things, they underline it, where they're going to remove things, they're going to strike it through. And then sometimes, maybe if it's a brand new section, maybe the whole thing is a brand new bill. But in this particular case, we're adding to the legislation or adding to the Florida statutes. All right, so we're going to get down here where we go. All right, so we start with the definitions. So one of the things that you always want to look at when you look at a bill is how are they defining words? Because you and I may use words differently. Think of it like this. If I say somebody's a bigot and you say somebody's a bigot, and you meaning whoever happens to be watching this podcast, it doesn't matter who you are, you and I may not have the same definition. So for the purposes of law, it's always good to make sure that whatever definition however they're using a word is fully understood. So here it says sex means the classification of a person as either male or female based on the organization of the human body of such person for a specific reproductive role as indicated by the person's sex chromosomes, naturally occurring sex hormones, and internal and external genitalia present at birth. I'm okay with that. Now, maybe some clever lawyer could come and nitpick away at that. For instance, the part here where it says for a specific reproductive role, right in the middle there, it says for a specific reproductive role. They might say, well, what if somebody doesn't want to? Does that in any way diminish, their sex? I'm not really sure, but just as a lay reading, I'm going to say I'm comfortable with it. So then it goes on and it defines sex reassignment prescriptions or procedures. So this is where this is kind of like defining gender affirming care. What does that mean? And a lot of people, when they talk about gender affirming care, they're almost like when they're arguing and debating and getting angry, a lot of times they will talk about it. You'll have person A who is opposed to it, and they may be focusing on surgery. And then after that, drawing a blank on it. After that, the pharmaceuticals such as puberty blockers and hormones. But then person B, who happens to support gender affirming care, they might include those three things, but then they might also include things like changing somebody's pronouns, or people changing their appearance in ways where they could change it on Monday and then go back on Tuesday, right? Like, so maybe they have long hair, and they do it up in a particular way so that it looks, maybe if it's a woman and she cuts her hair, so it looks more masculine, if you will. Maybe she wears clothes that are more masculine, men's clothing. So people would include those in gender affirming care and saying, like, look, part of the care is allowing somebody to express themselves. So definitions are important. So here, sex reassignment prescriptions or procedures. It includes three things. Number one, the prescription or administration of puberty blockers for the purpose of attempting to stop or delay normal puberty in order to affirm a person's perception of his or her sex if that perception is inconsistent with the person's sex. Okay, so now they've clarified exactly what this means. So we're not just talking about any use of puberty blockers, because the labeled use of puberty blockers is for precocious puberty, which means puberty that starts too early. And so it's given, and this is FDA approved, however you feel about that. It's FDA approved for the purpose of when a child is entering puberty too early, then you pause it to allow the child to not experience puberty until what's considered a more appropriate time. So you may not want your 8-year-old, I'm not sure exactly at the time, but maybe you don't want your 7-year-old going through puberty, and you want them to wait until they're about 11, right? Or something like that. So that's the idea. So what they're doing is they're making it very clear that this is for the purpose of somebody who wants to affirm the perception of their sex, which was defined a moment ago, if that is inconsistent, their perception, if it's inconsistent with their sex as they were born. All right. So then we move on, the prescription or administration of hormones or hormone antagonist to affirm a person's perception of his or her sex if that perception is inconsistent with the person's sex. Okay, same thing. So now we're just including hormones. And then we call out any medical procedure, including a surgical procedure, to affirm a person's perception of his or her sex if that perception is inconsistent with the person's sex. So basically what they're saying is, if you want to use pharmaceuticals or surgery in order to affirm your perception of your sex, if that perception is inconsistent with your actual biological sex, that's what they mean when they say sex reassignment prescriptions or procedures in this bill. Perfect. I don't have any problems with those. I think they're pretty straightforward, and they narrow it down to what it exactly is. And it doesn't appear to me that there's going to be much wiggle room to use it in a negative way elsewhere. So then, let's see. I read that. So then we continue on. We're going to skip past some of this stuff. So this is, let's see, what do we got here? So the term does not include, so it just kind of tells you what it excludes. We're not going to read the whole thing, but sex reassignment prescriptions and procedures are prohibited for patients younger than 18 years of age, except that. Okay, so first and foremost, everything we just read, that is prohibited for any patient who's under the age of 18. But then they have an exception, and I didn't highlight it because it's really long. I'm not going to read it all. I'm just going to give you a summary. Except if you've already been taking it. If you have already been on these pharmaceuticals, and I don't think that surgery is applicable. I think I read somewhere that no surgery has actually occurred for anybody under the age of 18 in Florida. Okay. So this is a grandfathering clause. It allows, if you're 16 years old and you have already been taking, some puberty blockers. Well, I guess you wouldn't be taking puberty blockers. Let's say you've been taking hormones at 16. Okay. And you've been taking them through a doctor's, under a doctor's supervision, then you're grandfathered in. That's going to be important in a minute. So we go on. Then we get to adults. So this bill actually applies to both children and adults. So I'm comfortable with the children. I don't know about the grandfathering clause, because it seems to me if there is a problem with utilizing pharmaceuticals in that way, then, and you say, hey, this is dangerous and damaging to the body, then is it appropriate to have a grandfather clause? Because either it's a good thing or it's a bad thing. And if it's a bad thing, then nobody should have them. Of course, the question then comes up, what are the ramifications of somebody who's already been taking them being taken off? Is it safer for them to just continue on? Or is it more safe for them to be gradually taken off, or should they just be cut off immediately? So those questions don't appear to be answered, and they just simply give you a grandfathering clause. But then we get to the adults here, and I've highlighted it in orange because I actually don't agree with this part. It says if sex reassignment prescriptions or procedures are prescribed for or administered or performed on patients 18 years of age or older, consent must be voluntary, informed, and in writing on forms adopted in rule by the Board of Medicine and the Board of Osteopathic Medicine. Now, that might sound legitimate, like, well, they just wanted to be informed. But here's the thing. We already have processes in place in our medical system for being informed about treatment. So there's no reason in my mind that you would need to add any additional burdens. Whenever I go to the doctor, if I go to the doctor, I've got a cold and I decided I want to go to the doctor because the cold's lasting longer than I was expecting it to. So then I go to the doctor so I can get some pharmaceuticals, right? Some drugs to take care of my cold. There's a good chance that I'm going to be filling out some forms, right? Especially if I haven't been there in a while. And if I go and I get a prescription filled out, I have to sign consent from the pharmacy. And, then I can even decline having, the pharmacist come out and tell me a little bit about the drugs, right? So there's already processes in place for all the consent. If I want to have surgery, man, do I got to fill out some forms. I got to fill out all kind of forms, right? I've got to go and talk to my insurance company. They've got to agree upon it, so like there are already processes in place for the proper level of consent for adults. And so then what they do is they go through here and they say consent to reassignment prescriptions or procedures is voluntary and informed only if the physician who is to prescribe or administer the pharmaceutical product or perform the procedure has, at a minimum, while physically present in the room, done these things. And so then it says, okay, in this law, we're defining what it means for consent to be voluntary, informed, and in writing. Here are the things that have to happen. Otherwise, it's a violation. So I oppose this. I oppose this section because we already have them in place. We are talking about somebody who's 18 and that person is an adult, maybe not mature, but they are an adult and they can legally, they can legally sign any kind of document that they want. And so in this particular case, I just see it as an absurd burden to that's been added in order to make it more difficult for adults to get the treatment that they want. And for me, even if I disagree, even if I think, you know what, you don't really need it, you just need to, maybe you need therapy, maybe you need to talk to a psychologist, whatever my opinion might be, that I think at the end of the day, I should not be able to legally prevent somebody from going and getting what they believe is the proper medical care. To me, that's a very dangerous path, and we don't want to itemize it based on how we feel about a particular thing. Because there are plenty of things in the medical community for which I would say you don't really need that. You don't need plastic surgery just because you don't like how your chin looks, or you don't like how your nose looks. We wouldn't want to apply the same burden for that. So for me, this part, get rid of it. So that's what I would have said. And I believe that's basically everything. It goes down here. Now it gets into what are the punishments for healthcare practitioners, doctors and whatnot for making violations of anything that was above. And then we go on and let's see here. I think that's it. Civil liability. So there's an opportunity for people to, so it says here a cause of action, and I didn't highlight it. A cause of action exists to recover damages for personal injury or death resulting from the provision of sex reassignment prescriptions or procedures as defined to a person younger than 18 years of age, which are prohibited. So this does it on the basis of what is prohibited. So you can actually go back and get some you can go back and hold people civilly liable for their actions. So I would have agreed probably with everything here. Maybe commenced within 20 years after the cessation or completion of the sex reassignment prescription or procedure. I think that's a fair amount of time. So I don't have a problem with somebody who is underage going back and getting restitution, especially since we have seen cases where these are the detransitioners. These are the folk who come out and they say, I, went in and I was all about having, gender reassignment procedures and prescriptions. And, they didn't give me enough pushback. They simply agreed with everything I said and they let me do it. And now look, I'm having all these problems. I think in those kind of cases, it's a good idea to allow, to say, all right, look, there is a means of legal recourse because you were a minor and, we are, anytime a minor is taking, is getting any treatment, whether it's pharmaceutical or surgical, they should always be permitted to go back and say, hey, doctor that did this, you are liable because you didn't put enough scrutiny under this thing that was a serious that could have serious long-term effects, right? And it doesn't matter whether it's for gender dysphoria or, hey, I needed a corrective eye surgery, right? If I go in, if I go in, let's say I'm 15, my parents take me in and I've got a problem with my eye, and the doctor says you need to have surgery. Okay, so I get the surgery, and then I start having complications from that surgery, years later, and then a bunch of other doctors go, there was no reason for you to have that surgery, and this information would have been known at that time. Then I should be able to go back and hold the doctor civilly liable for not doing a better job of providing medical care, right? And I think it's especially critical for children because part of the decision-making process includes children. It's not like a parent is dragging their, at least I hope not. It's, my understanding is that it's not that parents are just dragging their kids in and saying, doctor, my child is totally gender dysphoric. You need to take care of him and give him drugs, right? It's not like they're doing that. Of course, they might be, because that's what happens with ADHD medication. That's what's happened with SSRIs in some cases, right? Like you bring little Johnny in who's 5 or 6, and the parents are pretty much the ones that are doing all the time. Johnny's not communicating to the doctor so much. And so the doctor makes an assessment on the basis of Johnny's parents about whether or not they have ADHD and need to be prescribed some medication. So it's possible that it's also happening with children that are being diagnosed with gender dysphoria. Though if the child is older and can actually speak on their own behalf, I would assume that it's actually not happening, just because they can speak up and say, no, mom, that's not true, right? No, dad, that's not true. However, getting back to my original point here, if you're 13 and you're put on some medication and the doctor didn't thoroughly evaluate you and then determine, you know what, maybe medication isn't for you, then when you're 18 or 19, if you're having problems as a result of that medication, you should have some legal recourse. All right. So let's move on and let's talk about this decision and why the judge, because I think it's very interesting. And this kind of plays into some of my criticisms of people. Now, again, I oppose these kind of pharmaceuticals for these reasons, but I'm a little skeptical about whether or not the law is the best place to make it happen. And as we just saw, had I reviewed this bill last year, I would have pretty much agreed with everything except for the provision regarding adults. That I would have said is too restrictive, and you need to let adults make their own decisions, even if they want to make dumb ones. Okay, the same as we do in any other medical situation. Okay, as an adult, I can go in and tell the doctor that I might have ADHD, and I can, go through and then eventually get, Ritalin or some other medication as an adult. I can do that. And I can, as an adult, I can maybe fudge, some of the symptoms and be like, well, yeah, because we all know we're all pretty familiar with it. Right. And then that can happen with other drugs as well. And, and so I could go in and I could kind of help lead the doctor into the decision that I want. But I think it's very important that we understand the judge's position here so that we have a better understanding of whether or not the legal recourse is the way that we want to address this. And if it is, then how best to do it. So let's pull that up. All right, let's see what we got here. We got some, there we go. And bam, there we are. All right, so I'm going to read from this and we're going to bounce around to different pages here a little bit. So again, it's 105 pages long. So in the video, the woman said, this is a very thorough review of the bill. It's 105 pages. She's correct. It's 105 pages for a 10-page bill. That's pretty thorough. Now, whether or not it's good, I can't say. Will it hold up? When the governor and his team file an appeal and it goes to a higher court, I couldn't tell you. I'm not a legal scholar. I have no way of even guessing. I'm just going to read this from a layperson's perspective and kind of give you my opinion. So here's what it says on page 3. In this case, the plaintiffs assert an equal protection claim and the parents assert a substantive due process claim based on the right to direct the upbringing of their children. I mean, it's very interesting because in this case, what you have is you started out with 11 plaintiffs. There were 4 adults and 7 parents. Now it got narrowed down to 1 adult and 2 minors for various reasons. So it only ended up being about 3 people, but 4 adults and 7 parents came in, and 7 parents came in and said, look, we have the right to direct the upbringing of our children. Well, that's pretty important because outside of gender dysphoria, everybody would pretty much agree, right? If you think of any other medication, any other surgical procedure, when my son needed to have eye surgery, that was hence the illustration earlier. When my son needed to have eye surgery, it was a decision that I made between me and the doctor. And he had a bunch of tests and evaluations, and we were having a problem with his eye. It was turning inward. And the big concern was that it might correct itself and it might not. And if it didn't correct itself, the real problem was that because his eye was turning in, that the brain would say, hey, look, I'm getting some weird signals. So we're just going to ignore the signal from this eye. And what the doctor said was, once the brain decides to just ignore that signal, later, it's very, very difficult to retrain the brain to accept that signal. So therefore, we made the decision that he needed to have surgery to correct his eye so that the brain would get the signals that it was expecting, and that it would not say, you know what, to hell with it. We don't need this one. So we made that decision with the doctor. And plenty of other parents have made many other decisions for pharmaceuticals and for surgery. Now, granted, some of them, I would argue, were not appropriate. In most cases, I would say that ADHD medication, not appropriate. In most cases, I would argue SSRIs, not appropriate, especially the younger you get. If you're a young child, if you're like 8 or 9, and they're like, yeah, your child's depressed, I take big issue with that. Okay. But again, what we're trying to do is we're trying to evaluate, the parents' right to direct the upbringing of their children, which includes various forms of medical care. All right. The defendants explicitly acknowledged in Decker, that's a different court case, that preventing or impeding an individual from pursuing a transgender identity is not a legitimate state interest. Okay. So the defendants are, I've got it written down here, the Florida Surgeon General, the Florida Board of Medicine and its members, the Florida Board of Osteopathic Medicine and its members, and the state attorney. So those who the defendants are. And the defendants have explicitly acknowledged that preventing or impeding an individual from pursuing a transgender identity is not an interest of the state. So that's not what their goal is. And they have never receded from that concession. They assert instead that the statute and rules are a legitimate regulation of medical care and thus constitutional in all respects. So that's where we are. Okay. All right. So let's move on. We're going to skip over to page 4 here. The challenge provisions. And I'm skipping around a little bit just to kind of make it easier because we're trying to understand just in general why Hinkle made his decision. What was the rationale behind it? The kinds of care at issue are puberty blockers and cross-sex hormones. Okay, so the issues that the plaintiffs, the adults and the children and the parents have brought forward are puberty blockers and cross-sex hormones. This order uses the term gender-affirming care to refer only to these two kinds of treatment, not to gender-affirming surgery. Okay, so if anybody is going to complain and say, well, this is, they're going to allow surgery, that's not true. So we need to know the facts, because if we don't know the facts, then we can't speak competently, and effectively you can't win, right? Because this is, in my opinion, a combination of a cultural issue and a legal issue. And you cannot win by just running off at the mouth. We're going to see about that in a minute. So none of this applies to surgery. So as far as I understand, surgery is still blocked by the ban. So it's still banned because there was a severability clause, which I didn't get to, in the legislation. And the severability clause basically says, hey, if you find something wrong with this part, it doesn't mean the rest of it's all bad. So it basically means, if you find something wrong here, then here's what needs to be addressed, but the rest of it is still good to go. So this decision by Judge Hinkle only applies to puberty blockers and cross-sex hormones. So then he goes down and he says, for many years, the state of Florida allowed use of these medications to treat gender dysphoria. A report prepared by the Florida Agency for Healthcare Administration supported the use, but then the political winds changed. Now that's very interesting because I've argued in the past that one of the big problems that we face is that we're already primed to be in a certain area. In my podcast where I defended Chase Oliver, one of the points that I made, I said, we've already been primed to accept the idea that we can give pharmaceuticals to children for things that cannot be formally tested, right? In other words, if I go and I get my blood pressure taken, they are using an instrument that can be calibrated. And that calibration will determine, they put the cuff on my arm and they determine whether or not I have high blood pressure. And then based on all their research, they say, okay, if you have high blood pressure, which by the way, I'm happy to report that I don't, but if I did, then they could say, we're going to give you some medication and this medication is going to bring it down to an acceptable level. Again, based on our research. So then I come back in later after having taken the medication and they test it again and they determine whether or not the medication, the dosage is the appropriate dosage for me, right? So they might say, oh, wow, great. It looks like we brought it down to a level that we want. That's awesome. Continue with that dosage. Or they might say, you know what? We were kind of conservative in giving you this dosage. So we're going to increase the doses because it's not down far enough, right? So we've already been primed to give medication to kids without that kind of rigorous analysis, to give medication to kids on the basis of a parental testimony. This is why we keep bringing up ADHD medication, because there are not preschool, what's after preschool? Elementary. There are elementary school students who are on ADHD medication. These are not kids that can come in and talk to the doctor and tell them how they're feeling. So the medication is totally reliant on their parents, which is actually less than many of the puberty blockers, which would presumably have a child's testimony included and say, yeah, I don't feel like I'm a girl. I don't feel like I'm a boy. Okay. Now I'm not arguing in their favor. We're just trying to put this out there and understand, because you cannot win a battle if you don't understand the facts correctly. So one of the arguments is that the state of Florida has already been using these medicines specifically for gender dysphoria. That presents a bit of a problem. Why all of a sudden now? What is it now that has come to light that says we should no longer utilize this medication. It's a bad idea. And that's totally possible. Okay. Maybe we just didn't have the information that we did then. Maybe the pharmaceutical companies were covering up information like we've seen done in the past, right? Like there's any number of reasons why this happened. Now, Judge Hinkle here said the political winds have changed. That's also a possibility too. All right. So now we kind of get an idea of where he's going with this. All right. So we're going to move right along here. We're going to jump over to page 6. This statute also prohibits gender affirming surgery for minors and imposes restriction on surgery for adults. But the plaintiffs have not challenged, as part of this litigation, the prohibition on surgery for minors. What's up, buddy? The adult plaintiff for whom evidence was presented at trial does not seek surgery at this time, so he lacks standing to challenge the surgery restrictions. This order does not address surgery issues on the merits. So in other words, my presumption here is that the part of the ban that bans surgery for children and the part of the ban that imposes additional limitations for adults, which basically means they have to go through all these specific things and sign more documents and all that, that's still in place. That is not changed. So anybody telling you that now kids can have surgery, if you see that, you can correct them. We know what the facts say. All right. So now we're going to move on to the next page, and I'm going to try to hasten this a little bit. Gender identity is real, with extraordinarily rare exceptions not an issue here. Every person is born with external sex characteristics, male or female, and chromosomes that match. As the person goes through life, the person also has a gender identity, a deeply felt internal sense of being male or female. For more than 99% of people, the external sex characteristics and chromosomes, the determinants of what this order calls the person's natal sex, match the person's gender identity. Okay? So they're kind of putting it out there and saying, like, look, this gender identity is real. They go on later and they say gender identity is real. The record makes this clear. The defendants, speaking through their attorneys, have admitted it. So now both sides agree the idea of gender identity is a real thing. At least one defense expert also has admitted it. That expert is Dr. Stephen B. Levine, the only defense expert who has actually treated a significant number of transgender patients. That's pretty interesting. The defense agrees with this. The defense has an expert who has actually treated many transgender patients. All right. Let's see. I think he does say something. Wait, whatever. We'll skip on to the next part here. So let's go over to page 13. We're going to go down here. General acceptance of the standards of care. The overwhelming weight of medical authority supports treatment of transgender patients with GnRH and agonist, that's puberty blockers, and cross-sex hormones in appropriate circumstances. Organizations who have formally recognized this include the American Academy of Pediatrics, American Academy of Child and Adolescent Psychiatry, American Academy of Family Physicians, American College of Obstetricians and Gynecologists, American College of Physicians, American Medical Association, American Psychiatric Association, and at least a dozen more. Okay, so like they're pointing out all the major medical establishments, the national establishments, have determined that the treatment with puberty blockers and cross-sex hormones has appropriate circumstances. Now, whether you agree with it or not, it's not relevant. We're trying to understand where the judge is coming from. All right. That's our goal here. So then we go on. These medications, GnRH, agonist, testosterone, and estrogen, have been used for decades to treat other conditions. Their safety records and overall effects are well known. The Food and Drug Administration has approved their use, though not specifically to treat gender dysphoria. So in other words, gender dysphoria is an off-label use. But if you go and you look at other medication, you're going to find that off-label use is extremely common. So you cannot just use that argument and say, well, it's off-label, so therefore it's not a proper use of it. Now, the interesting part, and I don't remember if he gets into it. I don't think he does, the judge, is that it says their safety records and overall effects are well known because they've treated other conditions for decades. precocious puberty is one reason that they have used puberty blockers. There's other reasons that they use things that they use these medications for. So what's interesting is the question is whether or not the treatment for those was similar to the treatment for gender dysphoria, and how similar they would be if they are. So that might include the duration that they're used, the purpose, the end result, and then, what is the body doing, right? So maybe the body reacts one way if you're using a puberty blocker for the labeled use, but maybe the body reacts a different way when you're using it off label because the body is in a different state. Now, I don't know the answer to that, but I think those would be relevant questions to ask. All right, let's move on. We got a couple more here because it's going to get really interesting here in just a moment. So down here, it says under intermediate scrutiny based on sex. Now, there are levels of scrutiny that are used to determine whether or not a law is constitutional. I was going to include that, but then I thought that might be a little boring. So you can go look it up on your own. You can just go look up, intermediate scrutiny law, something like that. And then you'll find a whole bunch of videos and you can watch them. They're probably only 4 or 5 minutes, a little bit on the dry side. I've watched several of them, but it'll give you an understanding of the different levels of scrutiny. So it says, it is well established that drawing lines based on sex triggers intermediate scrutiny. Okay. So basically, when you draw a line and you say, we're going to do it because of your sex, then now there's a reason to scrutinize whether or not it's constitutional. So we go down here and we say, the defendants do not deny this. They're not denying a lot of things. Instead, they say the challenge statute does not draw a line based on sex, but the judge disagreed. Here's why. Consider an adolescent, perhaps age 16, that a physician wishes to treat with testosterone. Under the challenge statute, is the treatment legal or illegal? To know the answer, one must know the adolescent's sex. If the adolescent is a natal male, the treatment is legal. If the adolescent is a natal female, the treatment is illegal. Now, I would argue that where the judge is a little bit incorrect here is that, as we just read from the bill, it's if the treatment is for the purpose of gender dysphoria. So if it's for something else, it's not necessarily illegal. It's only if it's for dysphoria. Because as we read, the bill narrowed it down. So on that grounds, this could, maybe the judge's opinion here could be overturned. Not sure. I'm not a legal scholar. I'm just a guy that reads. So let's continue reading. All right. So then we go down here. Heightened scrutiny based on animus. Now, this is where it gets very interesting. Yes. Separate and apart from analysis to this point, invidious discriminatory purpose, actual animus against a disfavored group can also trigger heightened scrutiny. So in other words, if you've got some animus, like if there's some reason that's not, if you got like this problem with a person and you're a legislator and then you pass a bill, then the question is, did you pass the bill for legitimate grounds, or were you just using, what sounded like legitimate grounds to attack somebody else? So it's basically what they're saying here. Okay. So we're going to go on. Let's move over here. We're almost done. I promise you, folks. All right. The defendants say the legislature acted not to target transgenders, but only to regulate specific medical procedures. So they're like, look, we weren't targeting transgender kids. Yes, you can. They weren't targeting transgender community. They're just regulating procedures. So then the judge has to determine, what does the evidence say? And he goes, that is akin to saying that prior to Brown versus Board of Education, state legislators acted not to target African Americans, but only to regulate schools, and that this was not purposeful discrimination because all students, black and white equally, were required to go to school with students of their same race. So what he's doing is he's drawing this parallel and he's saying, they could have argued that segregation was not because they were trying to, do anything negative to black people, but they were just regulating schools. And since everybody was forced to go to school anyway, they were just regulating things. I'm not sure that this holds up, but it's an interesting point because The reason that I argue that legislation is maybe not the best way to go is because we've got years of legislation on things like hate crimes and discrimination and so on and so forth. So I kind of feel like the groundwork is already laid in favor of people that support these kind of things. So I'm not so sure that the law is the best place to go. And this is why we need to understand, everything. We need to understand the bills. We need to understand why the judge is tossing this out, so that if you want to counter this, you do so correctly. So then he goes on to ask, did legislators and board members act from animus against transgenders, or did they act from a belief, whether or not correct, that the treatments at issue are harmful, should be banned for minors, and should be prescribed with greater care for adults? Okay, so that's the question, right? Which one was it? And he said, so which is it? The evidence is on each side. In other words, he said it's a little bit of both. There's some animus, and there's some evidence that says, hey, maybe they really believed that the treatments were harmful and were passing a bill in good faith. So there's a little bit of good faith, there's a little bit of bad faith. The defendants have admitted this, acknowledging that preventing or impeding individuals from pursuing transgender identities is not a legitimate, non-discriminatory state interest. So the defendants have agreed, all of them. Hey, you know what? The state has no business stopping somebody from pursuing a transgender identity. Okay, so this is where it starts to get a little bit interesting. Some legislators plainly acted from old-fashioned discriminatory animus. A House member, for example, loudly referred to transgender witnesses at a committee hearing on a related bill as, quote, mutants and demons. We heard that from the news article that I read. This is direct evidence of that member's animus. In other words, he's saying, look, you were busy calling them names while you were acting in an official capacity. So there's evidence that really you were doing this in bad faith, even if there's some evidence of good faith. This is direct evidence that and it is unlikely he would have made a public statement of this kind, knowing it was being recorded for inclusion in the legislative history, if he did not believe at least some other legislators would share his view. Others who voted for the bill were present and none called him out. So in other words, he's just saying, like, look, the guy knew he could get away with saying this, and he didn't seem to care that it was being recorded, and nobody else called him out and said, hey, that's inappropriate, which they should have. They should have said, like, look, we're here as legislators, not moral legislators. We got to be neutral. Whether you might think that they're mutants and demons, but you can't say that, because it's going to cause a problem later when somebody challenges and says, why did you really pass this bill? That's a problem. All right. Other House members, the governor and the Surgeon General, have said there is no such thing as a transgender identity. That transgender identity is just ideological or made up or wokeism. But they agreed earlier that somebody could pursue a transgender identity if they want, and that the state can't stop them. This is why we need to have competent legislators, people that are going to go in there, evaluate the facts, and not run their mouths. Because when they run their mouths, then things start getting problematic. All right. So thus, and I didn't highlight this, but I'll read it anyway. Thus, for example, the sponsors of House Bill 1421, the House version of the Senate bill that was ultimately enacted. So in other words, it was a companion bill to the bill that we read, Bill 1421. It was in the House, because each side writes their own bill. They're generally pretty much the same, and then they come together and whatever. So you get how the process works. All right. So this is what he said. I can say I'm a porcupine, but that doesn't make it so. Also said, here are some statements that were said. We believe in science and we believe in biology, and there are X chromosomes and there are Y chromosomes, and what you're born with is what science said you are. And so you don't get to play choose your own adventure and change it. We cannot speak something into existence that doesn't exist. We cannot change our sex. The ultimate gender affirming care would be to tell children they are creatures of God, made in his image, that they were made the way they are, and there's absolutely nothing wrong with it. God doesn't make mistakes. Now, if you're a person who believes these things, that's fine. You're not a legislator. What you need to make sure is that your legislator doesn't run their mouth about these things, because they will lose. Because if I'm an atheist and I have a child and a legislator is passing a law that affects me, and it doesn't matter what it is, and they make a lot of comments about God and and that I might disagree with, then I have cause to go back and challenge that law and say, you made this law because I'm an atheist, because you don't like the fact that I'm an atheist. And this law affects me, and you didn't even do it in good faith. You are supposed to represent me, and you can't represent me if you're mocking me. This is problematic. I think there's one more thing I wanted to read here. Another House member said, the bill saves trans people and recognizes who they are in the eyes of God. Still another said, all people were created in the image of God. He created them, male and female. He created them. Folks, this is rock solid, irreversible truth. You are either male or female. This is not subject to one's opinion. Nobody who voted for the bill expressed disagreement with these statements or called the speakers out. All of this is direct evidence, or nearly so, that these legislators acted for the admittedly impermissible purposes of preventing or impeding transgender individuals from adhering to their transgender identities. So basically what happened, and I know that was a little bit dry and boring, but basically what happened is the judge threw out this law. He blocked this law partially on the basis that legislators ran their mouth. Rather than going in there and acting neutral and making legislation on the basis of facts, they ran their mouths about things that they cannot legislate on. They cannot make legislation and say, well, this legislation is because this is what God intended. They can't do that, nor should they. Because if you're a Christian, you might be inclined to say, well, that's not so bad. But it's only not so bad so long as it's your religious views. But if it's somebody else's religious views, if somebody comes along and they win and they pass a bill because Muhammad said so, or because it's what Buddha would want, or whatever, now all of a sudden you're going to have a problem with it for the same reason that people are having a problem with this bill. Now, whether or not this stands up in court when it goes to a higher court, I can't say. Maybe a higher court will say, maybe they'll reason that the statements made are not relevant and they'll give some rationale behind it. I don't know. What I do know is that right now, you, as the bill pointed out, number one, you have these medications have been used for many decades. They've also been used for a very long time for the specific purpose of gender dysphoria. That creates a problem. I don't want to say a problem, that creates an additional hurdle for all of a sudden banning them. You need to come out and say, why is it now that we're banning them when we've been allowing them to be used? In my episode where I defended Chase Oliver as the Libertarian Party's presidential nominee, I pointed out, I showed with evidence how many kids were receiving puberty blockers from 2017 to 2021. So I personally gave evidence going back to 2017 where kids were already receiving these pharmaceuticals for the purpose of gender dysphoria. Nobody had a problem with it then. All of a sudden, there's a problem with it now. The legislators have a duty to identify what is the problem now that we didn't know then. Maybe it's new information of some kind that's very relevant. Or maybe it's, as the judge said, the political winds have changed. But that it is the duty of the legislators to present that information. Then we have that the judge said, you know what? It looks like all the major medical organizations, maybe not all of them, but almost all of them, support this. So now we look and we say, who are our established medical authorities? What are they saying? Well, they're all saying This is a good thing in some instances, maybe not always. So now you have that hurdle that you have to overcome when you're making this legislation. Then you finally have the hurdle, and there's more in there. It's 105 pages, but then you have the hurdle of what was the intention of the legislators. And it makes it very hard for the legislators to say our intention was good faith when they're on record saying bad faith things. This is why it is absolutely critical for everyone to operate in the best faith that they can. Right? This is why we have to be careful. You can't, like, people run around and they'll go, they'll say, well, you support, mutilation of children. That's a garbage argument, and it's not helping your case. In fact, as we've seen in this decision, it could be harming your case, because if a higher court agrees with Hinkle's decision, then this bill is overturned. And the likelihood that DeSantis and the legislators is going to pass another one that's a little bit more robust is lower, because now they have to overcome all the hurdles in the Hinkle decision. Before that, they didn't have to, right? Before that, they only had to maybe overcome the obvious hurdles. But now they've got to overcome the obvious hurdles and all the hurdles provided in the Hinkle decision, especially if it's upheld. So this is why I have been on a rampage the way that I have. We cannot win a culture war or a legal war by just running off at the mouth and just saying whatever. The fact of the matter is, there's virtually not entirely. I think there's cases here and there, spot cases here and there of somebody under the age of 18 getting surgical procedures. But for the most part, that's not really happening. Like, that's not happening on some wide scale. And to my knowledge, it's never happened in Florida. So the idea that maybe, like, people might go out and say, well, Judge Hinkle just supports mutilating of children. That's actually not true, because it actually ignores that part of the bill, which means I would presumably take that to mean that it still stands. Right? So we have to understand what we're talking about. We cannot, when we're fighting something that's a hot button like this, we absolutely have to have our facts straight, and we have to be competent in our arguments. Think about Roe v. Wade. Roe v. Wade was once upon a time a hot topic, and the Supreme Court made a ruling, and many years later, that ruling got overturned. And even, who is the Supreme Court Justice? Ruth Bader Ginsburg. She actually, when she was being confirmed as a Supreme Court Justice, one of the big issues at hand was, wait a minute, are you really about the cause for women? Because she actually disagreed with the decision, the Roe v. Wade decision. Now, she disagreed with the structure of it. So she didn't necessarily disagree with the outcome. She said, I think the structure creates a problem and will actually not hold up in the long run. And it turns out she was right. Now, I don't know if she was right quite on the same grounds. I think they overturned it on slightly different grounds, but she was right in a sense. Okay. So you cannot have these arguments, and it doesn't matter what side you're on. We need to have good faith arguments. We need to have competent and intelligent arguments, which means we can't be running around just saying things like child mutilation. Those are meaningless terms at best, and at worst, they're going to cause problems when we go and fight it out in the courts. So stop doing it. All right, folks. Thank you for watching. Hope you found this episode informative and inspiring, and hopefully not too dry. I know we're reading bills and legislation 7 a.m. in the morning. Yeah, good job, bud. We're reading bills and legislation at 7 a.m. in the morning, and like, what in the world am I thinking? But I'm just trying to add some competency to the conversation. Be sure that you're subscribed to my YouTube channel or my Rumble channel if you prefer. You can go to youtube.libertydad.com or you can go to rumble.libertydad.com. Either way, while you're there, let me know how I'm doing by leaving me a comment. Last but not least, If you're a champion of liberty, your business is people and your product is liberty. I want you to have a great week. Catch you next time. But for now, I'm out.